We are getting ready to start. Good afternoon. I am really thrilled. My name is Kate Bartlett. I'm the dean here. I see some of you appear not to be law students, so I'll let you know who I am. I am thrilled today to welcome this year's Currie Lecture, named in honor of Professor Brainerd Currie, an expert in conflict of laws and one of the most distinguished scholars ever to teach at Duke. Since 1967, 2 years after Professor Currie's death, the series has brought to Duke a veritable who's who of the legal academy's most famous and productive scholars. Professor Siegel certainly belongs on that list. I've been a fan of hers since we met many years ago when she was on the faculty at UC Berkeley. In my mind, she is the best, most brilliant scholar of our time, writing in the overlap between constitutional law and constitutional history, inequality, and social movements. I have asked Professor Neil Siegel to introduce her. So, Professor Siegel.
Thank you, Dean Bartlett. I regard it as an honor and a pleasure to introduce this year's Currie Lecturer, Reva Siegel, the Katzenbach Professor of Law and Professor of American Studies at Yale University. Her writing draws on legal history to explore questions of law and inequality, and to analyze how popular movements interact with representative government and courts in shaping constitutional understanding. Professor Siegel is co-author of a leading constitutional law casebook, Processes of Constitutional Decision-Making, and co-editor, along with Catherine McKinnon, of Directions in Sexual Harassment Law. She's currently co-editing a collection of essays by progressive legal scholars entitled The Constitution in 2020. Professor Siegel's law review articles are too voluminous and influential for me to recount comprehensively. Well, I could do it, but you wouldn't like me if I did. I'll mention just a few here. First, her 2004 law review article in the Harvard Law Review entitled Equality Talk, Anti-Subordination and Anti-Classification Values and Constitutional Struggles over Brown. This provides a masterful historical account of the evolution of equal protection doctrine in the aftermath of Brown and the ensuing decades. When I read it for the first time, it caused my mind to do somersaults. And when I read it for the second time, it caused my mind to do somersaults. I don't often have that experience when I read a law review article. I assigned this piece to my first-year constitutional law students. I regard it as required reading for anyone who wants to understand what constitutional law is, where it comes from, why it changes over time, and how it legitimates itself. Another prominent piece that I'd like to talk about, her 2003 Yale Law Journal article, co-authored with Robert Post, who was my mentor in law school, entitled Legislative Constitutionalism and Section 5 Power, Polycentric Interpretation of the Family and Medical Leave Act. In my judgment, this piece represents the best work in the area of federalism in general and Section 5 of the 14th Amendment in particular in the last decade or so. Over her career, Professor Siegel has also explored the family as a site of citizenship struggle. A prominent example is her 2002 Harvard Law Review article entitled She the People, the 19th Amendment, Sex Equality, Federalism, and the Family. A number of her articles explore the link between abortion debates and questions of women's equality. One influential piece is her 1992 Stanford Law Review article entitled Reasoning from the Body, an historical perspective on abortion regulation and questions of equal protection. Recently, she's written on the role of abortion backlash in shaping the de facto Equal Rights Amendment, the rise of the new right, and the spread of woman-protective anti-abortion argument, the subject of today's lecture. Professor Siegel received her bachelor's degree, her master's of philosophy, and her law degree, all from Yale. She clerked for Judge Spotswood Robinson on the D.C. Circuit, and she began teaching at the University of California at Berkeley, a school that is near and dear to the heart of both Dean Bartlett and myself. She's on the boards of the American Society for Legal History, the Law and History Review, and the National Constitution Center. She's also active in the American Constitution Society, both in the national organization and as faculty advisor of the Yale's chapter. Now, there's much more that I could say about Reva Siegel's importance to modern constitutional law. I could talk about how often her work is cited, both by prominent scholars and by the Supreme Court of the United States. I could talk about what is widely known among law professors, which is that Harvard Law School really wants her, and Yale Law School really wants to keep her, but I prefer to end on a more personal note. I first encountered the name Reva Siegel when I was in college. I became friends with someone by the name of Beth Eastlick, who is still working at Duke, and her husband, Tom Ferraro is here today, and I understand he is a force of nature in the English department. And Beth said, "So, Neil Siegel, any relation to Reva Siegel? She may be the smartest person I've ever met." And I've since been asked that question on occasion. Just yesterday, one of my students asked me if I'm related to Reva Siegel. And I never out and out lie when people ask me this question. I never say, yes, in fact, she's my big sister, right? But at the same time, I'm also not anxious to disabuse them of the notion that we may be related and that some of her brain power may at some point have rubbed off on me. Today, Professor Siegel will deliver a lecture entitled "The Rights, Reasons, Constitutional Conflict, and the Spread of Women Protective Anti-Abortion Argument." Reva, on behalf of Duke Law School and Duke University, welcome.
Nice word. Okay, first thing I have to say is thank you, each of you, for that incredibly wonderful welcome. And it's really a delight. You can tell how vibrant a community is by the turnout people have to engage with lectures. And this is just a great scene, and I'm privileged and grateful to be a part of it. All right, so what I'm going to do today is to tell you a story, a history, a social movement history. That's going to be the bulk of this lecture. And I'm just going to read with a hope we'll also have time to do some Q&A. This is my pursuit of many of the themes discussed in the description of the articles that Neil just gave you, but at a very sort of fact-based level, trying to understand how constitutional arguments are living creatures that grow and move and develop in the world. And this is going to be an example of one of those that I'm in the middle of researching. Okay. On Election Day, the voters of South Dakota rejected an abortion ban that their legislature had enacted with the goal of overturning Roe against Wade. The law prohibited all abortions except those necessary to prevent the death of a pregnant woman. Discussion of the law generally emphasized the ban's reach and severity, obscuring until rather late in the referendum campaign another unusual feature of the law, its justification. The ban gave official endorsement to a claim that's been spreading for decades, that abortion harms women. This strategy of justification shaped the official legislative history of the ban, a 70-page report entitled "The Report of the South Dakota Task Force to Study Abortion," by far the most comprehensive government account of the arguments and evidence for protecting women from abortion. The report's findings included traditional fetal-focused items, emphasizing that a fetus is a whole, separate, unique, living human being, and reporting on new studies concerning the physiology of human development. But more than half of the 10 findings and over half of the report itself focused on its dual claim, that a regime of legally protected abortion posed a threat to women's freedom and a threat to women's health, exposing women to abortions that they do not want and in all events shouldn't have. The week before the referendum, the New York Times offered this account of the debate. Quote, "The most extreme arguments are nowhere to be found. No bloody fetus fills the billboards. No absolute claims are being offered about women's rights. Instead, in calls from a phone bank at the ban opponents' headquarters, volunteers quietly tell potential voters that the law is just too narrow, failing to allow abortions in circumstances like rape or incest. Supporters of the ban, meanwhile, speak in gentle tones about how abortion hurts women. Quote, "I refuse to show pictures of dead babies," said Leslie Unruh, who leads the Vote for Yes for Life campaign. That's the old way. That's what the old way was, and that's why they were losing all those years. We now know that voters in South Dakota rejected the ban their legislature had enacted, concerned that it lacked a rape incest exception. But the abortion harms women argument is spreading. Women protective anti-abortion argument figured prominently in the campaign in support of a trigger ban recently adopted in Louisiana, and it's been repeatedly invoked in Ohio, Mississippi, and other legislative arenas in which abortion restrictions are now being considered. It appears in briefs in Carhart, the late-term abortion case argued before the court this term, and it's distributed on websites of many, if not most, anti-abortion organizations today, especially on college campuses. The spread of the woman protective anti-abortion argument marks a dramatic expansion of the assault on Roe. For decades, constitutional debate has assumed that objection to Roe reflected concern about the unborn's right to life. No longer is public justification for abortion restrictions exclusively fetal-focused. In a growing number of political arenas, it's now expressly gender-based, consisting of claims about protecting women as well as the unborn. The South Dakota ban justified itself on the grounds that women in the state hadn't, in fact, chosen to have abortions. Rather, they were misled or coerced into having abortions. The task force report asserted that it had received testimony from 1,950 women reporting, quote, virtually all of them stated they thought their abortions were uninformed or coerced or both. The task force report asserted that women who had abortions could not have knowingly or willingly chosen the procedure and must have been misled or pressured into the decision by a parent, a partner, or even the clinic because, quote, it's so far outside the normal conduct of a mother to implicate herself in the killing of her own child, close quote. Alternatively, the task force asserted that even if women chose the procedure, they shouldn't have, because a woman who is encouraged to, quote, defy her very nature as a mother to protect her child, close quote, is likely, quote, to suffer significant psychological trauma and distress, close quote, and will be put at a risk of a variety of life-threatening illnesses, from bipolar disorder, post-traumatic stress disorder, suicidal ideation to breast cancer, citing studies whose findings have been repeatedly rejected by the APA, the AMA, the American College of Obstetricians and Gynecologists, the National Institute for Cancer, and the Centers for Disease Control. But the task force report rejected their findings and went on to embrace the task force findings based on alternative studies other than those of these governmental and professional organizations, and based the statute expressly on the ground that an abortion ban was to protect the rights and interests and health of the pregnant mother and also her fundamental, natural, intrinsic right to a relationship with her child, close quote. This shift from fetal focus to gender-based anti-abortion argument is of great, there are many who are perfectly well aware of it, but there are also large numbers of constitutional scholars who have not engaged with this argument. I actually encountered it myself when I was asked to engage with the legislative history of the South Dakota ban last year. And having written both on the abortion right itself in a series of articles advancing the sex equality framework for thinking about the problem, and also thinking about social movement conflict and the ways in which it can produce new constitutional understandings, articles that Neil had referred to earlier, I was fascinated by the appearance of new justifications for protecting the right to life, by the vivid evidence that there was ongoing evolution in the right's reasons. Since there was no available history of this claim, I set out to explore its roots using tools on the internet, movement literature, and whatnot in a search that's still ongoing. And so in today's talk, I'm going to give a little bit of my understanding of the history of this talk, this argument, where it came from, and how it developed. The story is going to start in the Reagan years with a provisional account of the construction of post-abortion syndrome and the first arguments within the anti-abortion movement about whether to justify the right to life on these terms. It was not just immediately embraced. I'm then going to follow this argument as it takes on a role in not in intra-movement struggle, but in inter-movement struggle over time, and takes up a life in the dispute between the choice and anti-abortion movements. And I'm going to conclude this story by thinking some about what it has to teach us, both about the character of the abortion right and the constitutional order that recognizes and protects it. So as you listen to the story I'm about to tell, you might ask, does the emergence of this new justification for restricting abortion strengthen or weaken the constitutionality of an abortion ban like the case for the constitutionality of an abortion ban like South Dakota's? Or you could focus differently and ask, what does the evolving shape of anti-abortion argument show us about the character of our constitutional order as a whole? So the day that the abortion ban statute was first introduced in South Dakota, there's testimony, actually it's available on the internet, I listened to this little pod on the internet, of various advocates for the ban telling the state legislature why it was that they should enact this ban, criminalizing abortion in all instances, but the case in which it's necessary to save the life of a pregnant woman, we hear the voice of Nicole Osmundson, who's counseling women at a Sioux Falls Crisis Pregnancy Center, a center that tries to deter women from having abortions. And she's telling the South Dakota legislature that women are, quote, victims of abortion who later suffer from depression, uncontrollable crying, bonding issues with subsequent children, regrets, drug and alcohol abuse, to eating disorders, to suicide events, to very, very destructive behaviors. I'm still quoting, the most significant example I can give you was the woman who could no longer vacuum her house because she couldn't hear the sound of a vacuum. It reminds her of the suction machine of her abortion procedure. Do they ever recover, she asked. I would fare to say no. In this account, a woman who has had an abortion has been injured in her very womanhood. She's impaired in her capacity to perform as a wife and a mother. The vacuum image is striking and recurrent. Indeed, I can find variants of Osmundson's claim reaching back to the 1980s. Consider Paula Irvin's Women Exploited the Other Victims of Abortion. In 1985, she quotes, "Some women can't vacuum their rugs because the sound of a vacuum cleaner reminds them of the fact they've had an abortion." Carol Kay is quoted as saying, "So when they're cleaning their rugs, they can't do it. They'll call their husband or a friend in to vacuum the rugs for them." The vacuum symptom expresses abortion's harm to women in the language of trauma and repressed memory. The claim is powerful enough that it's been repeated for 2 decades now. There are antecedents to this form of role-based argument against abortion. Claims that women who have aborted pregnancies would suffer for resisting pregnancy and motherhood were common in the medical profession's campaign to criminalize abortion and contraception in the 19th century, as I've described in this first article that Neil had mentioned. But in the years after Roe, the anti-abortion movement did not publicly advance its arguments for criminalizing abortion in these gender role-based terms. In this period, the movement's core arguments against abortion urged, it's a baby, and not, it's a mother. In the years after Roe, it was not the anti-abortion movement that was making claims about protecting women's choices and women's health. These were the claims and frames of the abortion rights adversaries. So how did the anti-abortion movement come to attack abortion in the language of the abortion rights claim? In arguing that legal protection for abortion threatens women's health and women's freedom, the Task Force on Abortion relied heavily on authorities in the national abortion movement, providing a chain of references that insist in reconstructing the genesis and spread of this argument, which I'm going to follow out now. So in what follows, I'm offering an initial account of the development and spread of the abortion harms women argument, which I understand to be a collective action frame. In order to explain how groups intervene in the interpretive domain and mobilize collective action, social movement theorists have developed a concept of collective action frames as action-oriented sets of beliefs and meanings that inspire and legitimate activities and campaigns of a social movement's organization. They've proposed that groups use, quote, frame alignment processes, this is a term of art in the literature, in order to connect individual and group orientations, to mobilize both identities and grievances, to recruit participation and support, and to advocate for political change. The story I've been able to sort of reconstruct so far suggests that woman-protective anti-abortion argument has both intra- and inter-movement logic. It's both expressive and strategic. As I'm going to discuss, claims about post-abortion syndrome first appeared in the 1980s as a therapeutic mobilizing discourse in the anti-abortion movement, deployed primarily amongst women volunteers and clients in the Crisis Pregnancy Center movement, in a period when the movement was itself arguing about abortion solely in fetal protective terms, solely with respect to protecting the unborn. Leaders of the anti-abortion movement who passionately argued about abortion as, in moral terms, about the importance of protecting the unborn, as you'll hear in this story, initially resist these woman-focused kinds of argument, but eventually come to embrace the claim strategically, under conditions of escalating social movement conflict, through a learning process in which they came to believe in the argument's power to persuade audiences outside the movement's ranks. So the first appearance of post-abortion syndrome is in the 1980s, Vincent Roux, who's cited multiply in this long task force report behind the ban campaign in South Dakota, is the author. And he was at this point in the 1980s a professor of family relations at the St. Thomas More Clinics of Southern California. And there's testimony in which he's describing abortion's social effects and beginning to talk about abortion as anti-family. This testimony talks about abortion as emasculating men, re-escalating the battle between the sexes, and proving to be a psychological Trojan horse for women. In this testimony, he asserts his view that abortion and guilt are virtually synonymous. It's superfluous to ask whether patients experience guilt. It's axiomatic they will. So this is an initial psychological argument. He elaborates this claim in the 1980s using the concept of post-traumatic stress disorder, which is just then being elaborated to account for the experience of Vietnam veterans. Roux and another woman named Ann Speckard essentially take the Diagnostic and Statistical Manuals, DSM's indicators for PTSD and expand it to the case of abortion as a stressor, even though the DSM still does not recognize this. In this form, the claim is advanced by a group called Women Exploited by Abortion, WEBA, and even though the APA was not endorsing this understanding of PTSD, this group spreads this claim through broadcasts, among other things, on the Christian Broadcast Network and through these CPCs, the Crisis Pregnancy Centers. And volunteers essentially are using this understanding of the wrong of abortion in order to deter other women from having abortions and talk about why it's necessary to come up with alternatives. As this is going on in the 1980s, this is not how the abortion debate is being conducted in public fora. Advocates such as Jack Wilkie of the National Right to Life Committee and Bernard Nathanson earned international renown by drawing on pictures of the developing embryo fetus in utero. Think of the silent scream, which is probably the sort of visual image that most comes to mind, is the figure of the anti-abortion argument in which the woman is completely outside the frame at this point. So interesting about the development of this argument. At abortion clinics, movement protesters sought to save the lives of the unborn by at times violent argument with providers and patients until such time as the movement could ratify a human life amendment. At this time, it's not simply that this argument, the woman protective argument, is overshadowed by fetal focus argument. It's actually powerfully opposed inside the anti-abortion movement as getting the moral stakes of the claim wrong. In 1980, I'm going to just give you a vignette, which is a fascinating moment in the life of this claim in the Reagan administration. In 1980, Reagan had been elected in part through the efforts of a new pan-Christian coalition that saw abortion as a sign of secular humanism and declining family values. Paul Weyrich, Viggory, and others who helped Jerry Falwell found the moral majority in 1978, proposed abortion as an issue around which Christians might mobilize. Anti-abortion advocates now had friends in the Oval Office, and as PAS claims began to spread in the anti-abortion movement, Reagan's advisors, Dinesh D'Souza and Gary Bauer, persuaded the president to ask his Surgeon General, C. Everett Koop, who was appointed as a well-known anti-abortion advocate, to make official findings that abortion posed a public health threat to women on the model of Koop's successful anti-smoking campaign. If Koop made such findings, D'Souza reasoned, the administration could argue that a changed understanding of Roe's factual premises warranted its reversal. But Koop, who had made his name as an opponent of the abortion right, refused to apply the public health anti-smoking paradigm to abortion, concluding instead that there was insufficient scientific evidence to draw conclusions about abortion's health consequences for women. Koop urged that the movement should keep its moral focus on protecting unborn life. Quote, the pro-life movement had always focused, rightly I thought, on the impact of abortion on the fetus, Koop reasoned. Quote, they lost their bearings when they approached the issue on the grounds of the health effect on the mother, close quote. Publicly discredited by the government's top anti-abortion advocate, the PAS argument might have died in the 1980s, but by 1990s, the anti-abortion cause itself was suffering a series of setbacks that empowered critics of the fetal-focused argument within the anti-abortion movement. Polls registered the American public's ambivalence and division about abortion and its recoil from clinic violence. In 1992, Bill Clinton, the first pro-choice president, was elected with support from the women's movement, and the Supreme Court, with its multitude of Republican appointees, preserved and narrowed Roe in the Casey opinion. With these setbacks and the anti-abortion debate, and the abortion debate at seemingly a stalemate, the anti-abortion movement began to explore strategic uses of woman-focused anti-abortion argument in order to appeal to the large sectors of the public that was ambivalently torn between the anti-abortion and the abortion rights movement. During the 1990s, this post-abortion syndrome talk is adapted for strategic use as an anti-abortion argument designed to reach those outside the ranks of the anti-abortion movement. So in 1990s, Jack Wilkie of the National Right to Life Committee, who had been one of the pioneers of this fetal-focused form of argument by showing the pictures of the embryo fetus as part of the anti-abortion debate, began to shift ground in the way in which he was arguing the case against abortion and start talking about the need to protect women's rights and welfare as a reason for criminalizing abortion. Here is Jack Wilkie in 2001 looking back at his change of course in the 1990s. So now I'm quoting Jack Wilkie of the National Right to Life Committee. We had been making steady progress in educating the nation beyond a reasonable doubt that human life in its complete form began at the first cell stage. Then anti-abortion advocates changed the question. No longer was our nation arguing about killing babies. The focus through their efforts had been shifted off the humanity of the unborn to focus on one of women's rights. They had developed the effective phrase, "Who decides?" Pro-lifers were still teaching in the traditional method that had brought such astounding and continuing success until that time. They were still proving that this was a baby and telling how abortion killed the baby. However, increasingly, these facts fell on deaf ears, for this did not address the new argument of women's rights. This had to be answered, but we did not know what the effective answer was. The only way to find out what would be was by effective, extensive market research. That's how they had come up with the idea of changing the question to who decides. That's how we would discover how to countermand their new sales pitch. This would require extensive research, focus groups, polling, and the testing of new ideas. We did the market research and came up with some surprising findings. We found out that while 3/4 or more of the people in the United States now admitted that this was a child who was killed, 2/3 of the same people felt that it was all right to give the woman the right to kill. We found out that the basic problem in the minds of the general public was, by their own evaluation, most were undecided. They felt that the pro-life people were not compassionate to women and that we were only quote-unquote fetus lovers who abandoned the mother after birth. They felt that we were violent, that we burned down clinics and shot abortionists. We were viewed as religious zealots who were not too well educated. Clearly, their image of us was one that had been fabricated and delivered to them in the print and broadcast media by a liberal press. After considerable research, we found out that the answer to their, quote, choice argument was a relatively simple, straightforward one. We had to convince the public that we were compassionate to women. Accordingly, we test-marketed variations of this theme. Thus was born the slogan, quote, love them both, close quote. And in fact, the third edition of our question and answer book has been so titled specifically for that reason. Wilkie and others in the movement, who had long argued the case against abortion by advancing the rights of the unborn, began to recognize that woman protective argument had strategic as well as mobilizing potential, affording a framework for arguing with those outside the ranks of the anti-abortion movement who might not share its animating convictions about matters of faith or family. Working with Wilkie, David Reardon, who had first begun advocating for PAS in the 1980s, translated the intuitions underlying the woman protective argument into a political strategy for the 1990s in a 1996 book, Making Abortion Rare. The title an ironic homage to Clinton, the first pro-choice president who found a powerful way of talking to middle America with his slogan of making abortion, quote, safe, legal, and rare. With clinic violence rising, Reardon joined Wilkie in arguing that the anti-abortion movement needed different strategy to appeal to the fence-sitting 50%. This is his quote. Fence-sitting 50% or more who feel torn between the woman and the child, close quote. Quote, accepting the fact that the middle majority's concerns are primarily focused on the woman is a prerequisite to developing a successful pro-woman, pro-life strategy, he emphasized. Reardon argued that this message of compassion could be expressed in the language of women's rights and in the language of public health. The key was to express opposition to abortion as a claim about women's welfare. Reardon's book, Making Abortion Rare, discusses the advantage of expressing judgments about the morality of abortion in the language of public health. Reardon views his empirical research on the psychological consequences of abortion at the Eliot Institute as documenting the moral evil of abortion and presenting it in terms that have authority for audiences not moved by direct appeals to divine authority. He writes, quote, Christians rightly anticipate that any advantage gained through violation of moral law is always temporary. It will inevitably be supplanted by alienation and suffering. Thus, if our faith is true, we would expect to find compelling evidence which demonstrates that such acts as abortion, fornication, and pornography lead, in the end, not to happiness and freedom, but to sorrow and enslavement. By finding this evidence and sharing it with others, we bear witness to the protective good of God's law in a way in which even unbelievers must respect, close quote. At all costs, Reardon counseled, anti-abortion advocates needed to avoid debates between the rights of women and the unborn, and to insist instead that, rightly understood, the best interests of women and the unborn do not conflict. A pregnant woman is a mother, and a mother's interests are always defined by the needs of her child, Reardon argued. With this understanding of women's nature, rights, and interests, the anti-abortion movement could develop a pro-woman, pro-life argument that appropriated the authority of women's rights talk. Quote, pro-choice advocates claim to be concerned about the welfare and autonomy of women. We claim to be more concerned for the very good reason that abortion is injuring women, not helping them, close quote. Reardon argued that the movement should, quote, take back the terms freedom of choice and reproductive freedom, close quote, and, quote, emphasize the fact that we are the ones who are really defending the right of women to make informed choice. I'm looking at the time, and I'm going to skip talking about, Frederica Matthews Green and Feminists for Life, which is itself a fascinating chapter in this story, but I want to save some time for talking about this. So, in this form, the PAS claim has spread in the anti-abortion movement, despite continuing objections from within the anti-abortion movement that the, quote, new rhetorical strategy, as a movement critic, Francis Beckwith, called it, compromises the movement's moral message and rests on suspect science. The claim is no longer a minority view in the anti-abortion movement or the gendered or restricted to the movement's CPCs. In 2003, Clark Forsyth, head of Americans United for Life, which designs legislative strategy designed to chip away at Roe, reviewed the movement's successes and failures and focused on the movement's need to counter the, quote, myth of abortion as a necessary evil. The key, he concluded, is to, quote, raise public consciousness of the negative impact of abortion on women. If it can be shown that abortion harms women as well as the unborn, it will not be seen as necessary, close quote. With attention to these developments and cross-currents in the anti-abortion movement, we can see that the South Dakota Task Force on Abortion was the site of a struggle, not only between friends and foes of the abortion right, but also a struggle within the anti-abortion movement itself about the kinds of evidence and arguments it would use to advance the case against abortion. The task force report was written in a process that alienated not only the minority in the task force that supported abortion rights, but remarkably also the anti-abortion chairwoman of the task force. The anti-abortion task force chair, Dr. Marty Allison, an obstetrician, voted against the report her task force produced and then campaigned against the South Dakota ban. Dr. Allison voted against the report issued by the task force she chaired because, she said, the task force voted against motions to restrict the evidence it heard to data, quote, that's consistent with current medical science and based on the most rigorous and objective scientific studies, close quote. The task force, the South Dakota task force, had relied on PAS studies authored by Rue and Reardon and others, even as it rejected contrary findings of the AMA, the APA, ACOG, and the National Cancer Institute. The task force report heavily relied on victim testimonies of women who regret abortions and grieve abortions and claim to have been coerced or pressured or mistaken into having abortions they did not want, while making no effort to ascertain the conditions under which this testimonial evidence was gathered. It came from Texas, not from South Dakota. Or, that is not all of it, but the 1,950 anecdotal accounts, that's the reference there. While making no effort to ascertain the conditions under which this testimonial evidence was gathered or to determine its representativeness. And, this is a point that Dr. Allison emphasized, while simultaneously excluding from the report conflicting testimony and evidence gathered by the South Dakota Task Force itself. Allison opposed the report also because she wanted the task force to recommend a ban with a rape incest exception. The final report excluded conflicting testimony that women supplied about raped women's need for abortion in favor of quoting Jack Wilkie's, "Why can't we love them both?" And also because Allison believed that any ban on abortion should be accompanied by policies to reduce unwanted pregnancy through educating teens about contraception as well as abstinence. That task force rejected all of these motions, instead included in the report an endorsement of abstinence-only sex ed curriculum, handing an important victory to Leslie Unruh, the national leader of an abstinence-only movement and the crisis pregnancy movement, who helped enact the ban and who then led the campaign to defend it. Okay, what does this look at the history, the rise and spread of the woman protective anti-abortion argument, tell us about the way in which this kind of claim spreads? My story suggests that women protective anti-abortion argument seems to spread inside the anti-abortion movement, not simply because it's strategic, but also because the claim is persuasive to growing numbers of anti-abortion advocates, even as it's resisted by others in the movement. The anti-abortion claim is now carried by a coalition of groups, the Traditional Family Values Coalition, brokered by the Republican Party in the 1980s, which together endorse a more expansive understanding of anti-abortion's morality, expressly grounded in commitments about sexuality and family roles, and not simply restricted to concerns about protecting the embryo fetus. This vision, which includes a commitment to abstinence, a commitment to heterosexual marriage, and an ethic of privatized responsibility and dependency, is set forth in movement statements of principles such as America We Seek, which was published in First Things in the late 1990s, or the Natural Family Manifesto that many of the traditional family values groups have endorsed in 2005. It's because anti-abortion advocacy is now nested in this broad-based coalition that the South Dakota Family Policy Council held a Protecting Life and Marriage rally in support of referendum provisions last November, banning abortion and also same-sex marriage that were simultaneously on the ballot. At that rally, keynote speaker Alan Keyes called abortion and same-sex marriage, quote, "one and the same issue," close quote. Quote, "Abortion does at the physical level what homosexual marriage does at the institutional level," close quote, he said, explaining that both go against what God intended. We could spend the rest of the day unpacking Keyes' claim. Suffice it to say that for present purposes, it goes beyond the claim that a fertilized egg is a person. Women protective anti-abortion argument expresses the anti-abortion claim in Keyes' more expansive normative register, telling of the individual suffering and social disrepair that flows from breach of sex and family role morality that many in the movement believe God has ordained. But woman protective anti-abortion argument is not just a movement creed. As we've seen, it grew up also as a movement strategy, a hybrid discourse that evolved in an effort to argue about the morality of abortion with those outside the ranks of the traditional family values movement. How then does woman protective anti-abortion argument persuade Americans outside the ranks of this movement? The middle, fence-sitting majority of Americans for whom, as we have seen, women protective anti-abortion argument was designed to appeal. Movement strategists decided that these Americans were sufficiently concerned about women's welfare and women's rights that they could not be persuaded to adopt restrictions on abortion solely for the purposes of protecting the unborn. To assuage the concerns of this audience, South Dakota has appropriated the language of the abortion rights movement to justify its abortion ban, claiming that banning abortions will protect women's health and their freedom of choice. But how exactly is this claim persuasive? It persuades, if it persuades, by fusing some relatively new forms of talk about women's rights with some very old forms of talk about women's roles. Abortion must harm women because women are by nature mothers. Choosing against motherhood and subverting the physiology of pregnancy will make women ill, and in all events can't represent what women really want because any real woman wants what's best for her child. Women who seek abortions must have been confused or misled or coerced into the decision to abort a pregnancy, because the choice to abort a pregnancy can't reflect a normal, I'm quoting from the task force report, a normal woman's true desires or interests. Using law to restrict abortion protects women from such pressures and confusions and frees women to be true women. I would like to conclude with a few reflections on the way in which my story bears on understanding of the abortion right and the constitutional order that protects it. Anti-abortion advocates have decided that the public's willingness to adopt restrictions on abortion crucially turns on judgments about women, and they've devised a way of arguing their case with the public that's designed to quell these concerns. The problem is that their appeal depends for its persuasive power on ancient stereotypes about women's capacity and ancient stereotypes about women's roles. So much so that I'm prepared to argue that a law like South Dakota's violates not only Roe and Casey, but also the court's equal protection sex discrimination cases. If the public would not ban abortion to protect the unborn, but for the state's claim also to be protecting women, as Jack Wilkie and David Reardon and Leslie Unruh seem to be saying, then it's fair to say that this use of public power is sex-based state action that reflects and enforces constitutionally prohibited gender stereotypes about women, that all women are mothers, that all women are self-sacrificing, as men are not. The South Dakota statute is a life-defining exercise of public power against women premised on the view that government knows better than women do what a real, normal woman really wants and needs. Whether or not South Dakota's law violates equal protection as presently understood, and I would argue that the case is strong that it does, gender stereotyping of this kind has a pernicious effect on our politics for just the reasons we treat gender stereotypes as constitutionally suspect. Women protective anti-abortion argument taps ancient forms of talk about women that abate public concern about coercive uses of state power against women. Women protective anti-abortion argument obscures the actual reasons women seek abortions and offers little in response to these needs. Criminalizing abortion would not, for instance, address the needs of women who seek abortion because they lacked contraception, or were raped, or are living alone in an abusive relationship, or will have to drop out of work or school to raise a child alone, or are stretched so thin that they cannot emotionally or financially provide for their other children. Criminalizing abortion assuredly does not help women control the timing of motherhood. Normal women seek abortion for all of these reasons, which criminal abortion laws would not repair. Criminal abortion laws cannot give women emotional or financial support or counseling or love, but they can restrict, degrade, and endanger women, especially women who do not want or are not able to conform their lives to the vision of the good life that seems to fund the South Dakota Task Force report, abstinence before marriage and economic dependence within it. Of course, criminal abortion statutes symbolize respect for family values, but they instrumentalize, in my judgment, too many women's lives in the process, dividing women who well might make common cause in other contexts. Our ongoing debate over the criminalization of abortion may well prevent women who live in diverse relationship to the institution of motherhood from identifying the kinds of claims on the state through which they could, in fact, make common cause with one another. So to wrap up here, in my judgment, the good news about the appearance of women protective anti-abortion argument is that it makes brutally, publicly clear that abortion regulation concerns judgments about women and not simply the protection of unborn life. From my standpoint, the bad news is that women protective anti-abortion argument blunts public compunction about the coercive use of state power by actuating ancient stories about women's agency and women's roles that the court has repudiated in its equal protection sex discrimination cases, but which still have potent purchase on public imagination. On the other hand, the good news is that even if these stereotypes persist and continue to shape debate about the kinds of family life government should support, we can see in the abortion debate itself that the equal citizenship norms the court has recognized in its 1970 sex discrimination cases also have life in public imagination. Women's rights and needs matter to the voting public, to whom advocates for abortion restrictions are appealing. They even matter to members of the anti-abortion movement itself, so much so that these equal citizenship norms are now beginning to be integrated into the anti-abortion argument itself. The good news is that, with women protective anti-abortion argument, the anti-abortion movement itself seems to be acknowledging that restrictions on abortion must respect women's autonomy and welfare, even if Americans continue to argue what that means. To be sure, given my normative priors, I see plenty of bad news in this story. The story I've told may suggest the path through which the court will ultimately eviscerate Roe and claim to reconcile criminal abortion laws with Roe's remnants. But we may also be looking at the emergence of a new set of constitutional norms that will constrain abortion regulation in the 21st century, a constitutional commitment to women's dignity and equality, constitutional values to which Justice Kennedy and others in the normative middle of this debate remain responsive whether Roe lives or dies. In fact, we don't yet know, and there's some good news in all that. In all of this Roe rage, we're also looking at forms of community that I, for one, find strangely moving. Agonists in this debate are short on respect and tolerance for one another, but the need to persuade the uncommitted public engages them, however indirectly, in dialogue with one another in more ways than we're generally inclined to notice. In this story, both sides give ground in an effort to make persuasive constitutional claims, claims which the American people and its courts may prove responsive. The court plays a crucial role in this story, but only in part down as top-down dispute settler. It imposes important ground rules on the conduct of democracy, and the public pushes back, perhaps becoming more reflective and differently engaged in the pushback process. This pushback is loud, angry, divisive, and it often seems counterproductive. But it's also normatively creative and gives rise to forms of community in more ways than we often appreciate. We worry about backlash and imagine a more prudent court to which all would defer. But in truth, few of us would want to live perpetually in such a relation to constitutional law, deferential, passive, or subject. The process of constitutional elaboration we're looking at lacks the grand splendor of our narratives of constitutional lawmaking at the founding or at Reconstruction. But it is a practice and a politics of constitutional lawmaking in which all of us are engaged, and democratic in more ways than we yet have a vocabulary to describe. Thank you.
So let me just thank Professor Riegel for a very fascinating and provocative talk. She has time for a few questions, and I'm going to let her field them herself. So, the floor is open.
Okay, good.
I was curious if these types of arguments came up in the 2003 abortion ban, or the so-called partial birth abortion, because I know when it was argued in San Francisco, Eve Gartner just had so much medical support for Planned Parenthood's position, and I was wondering if it came up in that context or then in October before the Supreme Court.
Yeah, if you take some of the names I'm talking about, Rue and Reardon and all, and you just go do some Westlaw searches of the briefs in these cases, you will discover that there are lots of versions of this argument that have come in amicus briefs. And even Phyllis Schlafly has a brief in which she's making the smoking argument. She said, you don't need a health exception. That's like making a health exception to a cigarette ban. That's her argument in this brief. So it's sort of in line with the Coop claim. So it's there. I think that my fascination with this, I have not consistently written about abortion. I've been doing it in the last year or so, but I started out, my first article was this article, Reasoning from the Body, and it was just before Casey, and at that point in time, I was essentially writing to say, even if Roe is overruled, there's still constitutional values that limit the forms of regulation of women's reproductive lives in the Constitution. They're equality-based, and I used all this 19th century history. That article is a 120-page article with tons of history of doctors making arguments, not in PTSD language, but in 19th century idiom about the harms of abortion to women. And in that piece, I was endlessly talking to people who would say, well, sure, in the 19th century they argued this way, but it has nothing to do with now. The argument was assumed to be solely fetal protective and having no element of judgments about women. In fact, this argument was already circulating, and it is has a long life before it comes into view. I was saying to Dean Bartlett earlier before I talked that I think that there's a certain way in which the focus of supporters of Roe has been trying to identify what's the strongest counterargument to which they need to be responsive. And in terms of sort of the secular humanist value, the harm principle, protecting the unborn, is the most worthy adversary. That's the argument that needs to be answered, and that's where that's taken to be everything that this claim is about. So in a certain way, there's just been ignoring of all of the forms of coupling of the abortion argument with the sets of natural sort of political claims, which if you look on the net, groups that are making energy opposing abortion are often opposing or advocating abstinence education or alternately taking positions on same-sex marriage. And you can't derive these positions just from looking at the physiology of the embryo fetus. That's just not a sufficient lens. So somehow or other, there's been a way in which the argument has been abstracted out of that larger structure. And in doing this work, in part, I'm sort of recontextualizing a set of genuinely held, passionate concerns in a larger sort of normative universe. Even so, I'm also trying to show that there's differences of point of view inside of a movement. It's not just one argument against another. It's groups of people who see the world in different ways coming together around certain claims. But within each movement, there are different views, and in part, in some measure, pressing on these sets of issues, maybe it could turn out that there are allies that crisscross the two movements. Yeah?
Do you have a prediction on how the court's going to decide the current so-called partial birth abortion ban cases?
Oh, I'm not an insider on this one. I was on a panel with Jeff Rosen at AALS, and he talked about the court narrowly construing the statute so it didn't do what Congress wanted it to do and then upholding it. In other words, rewriting the statute. And I thought, well, that sounds like an inside the beltway sort of idea of how it might be possible to compromise. But I'm not prepared to say that that's what Kennedy, there's different ways in which Justice Kennedy can understand this. He can understand it as a stare decisis, can understand it in a Bernie kind of way, or he can understand it in a Carhart kind of, Stenberg kind of way, and we'll see. Yeah.
Two questions. First, you have spent more than half of your lecture trying to sort of make an argument that arguments of anti-abortion groups, are based on ancient stereotypes and so on and so forth. And you've only once in your lecture mentioned that one real flaw in the criminal anti-abortion statutes is that they do not provide any kind of reasonable alternative. And to me, that argument is
I'm sorry, reasonable alternative.
Like, they do not provide any kind of prevention programs, any kind of counseling for women, and what I'm trying to say is that I think that this argument is much more persuasive, and this is why. Men do not have a right, either constitutional or statutory, to have children. And you know, if a state or a group of men are to force a woman to have a child for them, they must make it worthwhile for a woman to make birth to a child.
So-
and that speaks to the reason why, if you were to outlaw abortion, you should provide like reasonable alternatives or accommodations.
Okay, very helpful. In this earlier piece that I talk about, this it's called Reasoning from the Body, this first cut at it, that was not focused on this particular kind of argument, the woman protective argument. It was focused on just the most familiar core claim about the state's need to protect the embryo fetus. And in that article, I was trying to say, just as in the 19th century, you could see not that those concerns aren't genuine, but that there are also judgments about women at the same time. It's sort of concurrent sets of judgments. I there pointed out that you could see evidence of the persistence of what was expressed in the 19th century into the 20th century by looking at the structure of the bans. You could say that the state has no judgments about women one way or another, doesn't have any value judgments about women, it's just regulating women because women are where the embryo fetus is. But per this kind of concern, that doesn't give an account of why no criminal abortion ban is accompanied by provisions for the woman who's been conscripted, meaning essentially various ways of accommodating, conceivably remunerating, alternately involving fathers of the children as well. That argument at the time that I made it was just simply to illuminate that gender judgment entered into arguments for criminalizing abortion, whether or not it was made express, as it was in the 19th century and as it is in some of these arguments. But there are people now who are trying to act on that intuition, not just by way of trying to prove latent bias in proponents of criminalization, but actually to come up with compromise alternatives to the kind of alternatives that 24-hour waiting periods and parental consent forms of, or TRAP, clinic regulation laws represent. And Rosa DeLauro and other people on the Hill have proposed various bills that are referred to sometimes as abortion prevention bills. And what they are provisions for giving public support to helping people reduce the number of unwanted pregnancies, so enhancing people's choice about whether or not, when they're sexually active, they become parents. And also providing support for those who, finding themselves pregnant, might be inclined to bring a pregnancy to term if they had the resources to do it. That is to say, these bills conceive of themselves as intervening in the conditions under which children are conceived and raised in order to reduce the number of undesired abortions without using the criminal law to criminalize abortion. And there are proposals on the Hill, and they're there as essentially efforts to speak to, I said that it might be possible to draw different lines that would cut through these coalitions. Well, what that kind of a proposal does is sort out those who oppose abortion because of concern about the welfare of the embryo fetus from those who oppose abortion because they think that that sex is sacred, should be reserved to the marital relationship and for procreative purposes, and you don't need to enable people to have sexual encounter without reproductive consequence because that's not a good form of sex to promote. So in fact, Leslie Unruh and others, Leslie Unruh, who led the campaign to ban abortion in South Dakota as the head of the National Abstinence Clearinghouse. It sounds like, this is a plausible place to end this. It sounds, I told you a story in which the ban was defeated in the referendum, although people focused on the lack of a rape incest exception, not their objections to this woman protective anti-abortion argument. So I said, nonetheless, it's spreading. the medical advisor to Leslie Unruh's National Abstinence Clearinghouse, is now the head of Title X money in the United States. Kerouac is the person who's in charge, medical advisor who counsels abstinence, is now in charge of all the $400 million worth of family planning monies in the United States right now. And he argues that if you look on blogs and you look on the net, you'll find that he had all these PowerPoints arguing that extramarital sexual encounter reduces people's capacity for marital intimacy. So that's a coalition inside the anti-abortion movement that potentially could be split by something like this abortion reduction kind of regulation, where you're saying you don't necessarily give support to the abortion right, but you ask people to sort of take a position on the question of wanted and unwanted pregnancy support for sex ed and contraception. That's what split the task force, as I was describing it to you. That's the head of the task force was an anti-abortion obstetrician who believed that in the course of recommending the ban, the state should also adopt sex ed and essentially help deter unwanted pregnancies. That view the ban itself was rejecting. So that just tells us at the end of the day that this conversation is about the conditions of sexual intimacy and the vision that we have of the family, and not just the reproduction of the physiology of reproduction, and that we need to have this larger understanding. And when we do, we may find out that it's possible to find points of dialogue that cut differently than just pro-choice and pro-life.